Hello and welcome to the Kenneth Verkamel Office Legal Podcast, the NJ Laws Tube. In this edition, we look at preparation for the municipal court case, and this is part of the New Jersey Institute for Continuing Legal Education program, the Municipal Court College. Let's see, and we discuss how the attorney prepares for a municipal court case, the telephone call. Let's see. Now, in my career, municipal court to me is a little bit like the TV show Cheers. Everyone knows your name. More experienced attorneys are helping out newer attorneys. So when the phone rings, all right, a potential new client, I'd say, well, typically it's not a good idea for the attorney to give legal advice over the phone, but rather have the person come in and realize the seriousness of the case. I'd say we'll sometimes let them know what the penalties are, but we want the person to come in, I'd say, and take the time. If it's important enough for them to need an attorney, it's important enough for them to take time out of life to come in. Let's see. So what we do is we will email them the confidential questionnaire, and we'll tell them to make sure that when they come into the office for the appointment, bring a copy of the complaint, any papers they received, the hearing notice, an accident, get the accident report if there's an accident, and any documents they received from the court, the police, insurance company, or motor vehicles. 2, the in-office interview. I'd say, we make sure that they've completely filled out the criminal interview sheet. Let's see, we need information, their name, their address, their age, their background, prior offenses, the date of the arrest, any witnesses. Let's say we have a question. It used to be, what statements did he give? But people think, well, a statement is something that might be written down. Instead, we ask them simply, what did you say? What did you say? And we ask them, again, what prior arrests do they have? And then question, what prior charges? Because sometimes people don't understand a charge doesn't have to be an arrest. So it's like it's charges, because people think an arrest is only if they were brought to the police station. I'd say any matter that was state versus someone and it was a criminal matter, we need to know about. That's important. I'd say we'll discuss with them the charges. Sometimes show them the statute, explain what the penalties are. 2, or actually number 3, being retained. Let's see, New Jersey Rule of Professional, Conduct 1:11-2, indicate a retainer letter or written statement of fees is required for new clients. Let's see, so we provide them with something in writing that advises what the fees are, information on surcharges, points. Let's see, noted Beverly Hills attorney Jay Fulmberg said, the fee, get it up front. So my office and most good attorneys, they do it on flat fee, and they require all the fee be done up front. So if a client comes in, they're not willing to pay for the attorney, well, then they're usually not going to get a client. Once we're retained, we do the discovery letter right away while they're sitting there. I'll do it on my own laptop. Let's say we'll prepare a letter of representation to the court. Let's say, and anything else that needs to be done right away. Sometimes calling the court, sometimes faxing the court. Yes, we represent this particular person. Let's say we suggest to the client they should prepare a list of 10 to 15 reasons why they should not go to jail, why the court should not impose the maximum penalties. Let's see, why they should get minimum license suspension. When there's motor vehicle tickets, we suggest they get a motor vehicle abstract, because the judge will know what their abstract is, and if many of the clients aren't sure, and therefore they should be sure. It also helps that if someone just simply wants a no-point ticket, that they're eligible for that no-point ticket. If the court date is pending, in addition to us doing a letter of rep, we suggest to the client, hey, we want you to call the court and tell me you're pleading not guilty. This way, we're certain that they know that a not guilty plea is being entered. 4, post-interview work. If it's a drug case, we'll file a conditional discharge, and we actually do it in writing. And I have a form that I use because I want the client to represent in writing to the court. I don't have any prior drug arrests, no drug convictions. I understand it's a minimum $500 in DETR penalties, and I could lose my license. Let's say it's better to be over-prepared than under-prepared. Sometimes we'll do a motion to suppress. Let's see. If there's a private citizen case, that means private citizen complainant, not a police officer signed the complaint. we serve a discovery letter on the complainant as well as the prosecutor. That private citizen complainant letter we send by UPS or Federal Express. 5. Discovery. If we don't get discovery within 10 days, we may send a follow-up letter. Sometimes I just simply file a motion to compel discovery. Let's see, this way, oftentimes it wakes someone up. And the motion to compel discovery is called a HOLUP motion, HOLUP. And I have a form on that. Let's see, this way, the burden is upon the prosecutor. Hey, why haven't they responded? Sometimes we'll also send the follow-up with a request to the police department in the event the prosecutor did not forward that discovery request. Let's see, check the lawyer's diary. Know who the judge is. It is important to know who the judge is and who the prosecutor is. Let's see, one judge, for some unknown reason, was automatically giving people 45 days in jail on a second offense, DWI. Automatically. Let's see, now, that's bad news for the client, but it's better to know bad news ahead of time than when they go to court thinking that, okay, all I need is a ride home tonight. 6. Preparing for court. If it's a drug case, we do a motion to object to the lab report. This way we have some bargaining with the prosecutor, and if there is not an objection to the lab report automatically goes in. So it's important to file that and any other motions ahead of time. Let's say if there is a new case or even old case favorable to the defense, make 3 photocopies. 1 for the prosecutor, 1 for the judge, and 1 for the client. Never assume the prosecutor or the judge is familiar with all the cases. Sometimes it's a fill-in prosecutor. Let's see. In my car, I keep certain books getting ready for trial, just in case. The court rules, Gann edition, the police manual, evidence book, and any other sometimes some forms. Now, let's say witnesses. Let's say if you have witnesses you need for court, send a subpoena, and the court rules were revised that the court should notify the witnesses. It was previously unfair because the court was sending notices to all the state's witnesses, and sometimes I would say, oh, please also include this person on the notice list, and a court responded, well, we only notify the police witnesses. I said, well, that's unfair. Let's see, I thought that little circly thing with the scale of justice that is on the municipal court stationery said, justice, etc., etc. Well, the court rule was revised. If you have a witness, you can request that the state that the court send notices to your witnesses as well. Let's see, lawyer's diary. There's a list of points in there, so it's a good idea to carry with you at all times a list of points. I also carry with me the list of the motor vehicle code, so I can easily review abstracts and look up priors. Let's see, and in my booklet materials, I have those court codes. So that's important to know. The court will send a hearing notice to the attorney and the defendant. We send a follow-up letter to the client. Your court date is this date, this time. Let's say if you have any character references, letters of reference, bring those. Be there on time, wear neat clothes. Let's see. And also say, bring something to read, hearings are delayed, and don't panic. Let's see. If I know I'm coming from somewhere else, we send what's called a late fax. This way it says, Ken Burkham is coming from Somerset and may be delayed. This way the court doesn't wonder where I am at because I'm on my feet somewhere else. I keep in my car, in addition to those books, in order to compel discovery, in order to mark trial or dismiss, in order to be relieved. If I know that there's an issue that the client may want to appeal, then I keep an appeal notice. I bring an appeal notice form. 7. Going to court. Well, sometimes, say you realize, well, the only way the state can prove their case is if the police officer is around. So, while driving to court, occasionally I will call the police department and say, get the dispatcher and say, hi, this is Attorney Ken Burkham, and I have a case with Officer Dunn. I'm going to be in the building. Is Officer Dunn going to be around this afternoon at around 2 o'clock that I might be able to chat with Officer Dunn for a couple minutes? Let's see. We're not saying, hi, I have a case against Officer Dunn. And sometimes the dispatcher will look up and say, yes, is working today, or sometimes they give you the inquisition. Why do you need to talk to them? Well, we have a pending case, and I was hoping to stop in and talk for a little while. The dispatcher may say, no, Officer Dunn's not working today. Officer Dunn's on vacation. Officer Dunn's on sick leave. Well, that's certainly helpful in negotiating your plea with the prosecutor. Let's say you work out your plea with the prosecutor. Write on the plea form. Let's say no jail, no probation, no license suspension as part of plea. Rather than just saying prosecutor recommends. Well, the prosecutor recommend anything, the judge is not bound. We want the judge to be bound. If the judge doesn't want to accept it, hey, that's a judge's call, just like in Superior Court. But this way, the client then, if the judge doesn't want to accept that, the client has the option of not going along with the plea. Let's say there's other information on representation in municipal court cases, and we've put some of that on website njlaws.com. That's njlaws.com. Also on website benotguilty.com. That's benotguilty.com. For other information, call the Law Office of Kenneth Verkaman at 732-572-0500. Let's see, the full video, or audio, which is about 3 hours long, is available regarding the Municipal College from the New Jersey Institute for Continuing Legal Education. Phone number 732-249-5100. Thank you and good luck.